Hello, my name is Stephen Brown. I'm a partner here at Reddy Neumann PC in Houston, Texas. Today I wanted to discuss one of the unique attributes of Reddy Neumann PC, and that's our litigation practice. I manage our firm's litigation practice where we sue the government on various immigration delays and denials of benefits. And there's a wide range of things that can and cannot be sued on, and always happy to discuss a delay or denial that you may have. And we've represented both businesses and individuals, depending on the type of delay or denial, to get the benefit, hopefully moving in the right direction. And I wanted today to talk about some of the cases we've done recently, as well as some of the cases that are a little bit in the past that are still ongoing, to provide some updates. So one of the cases that we've been doing a good amount of recently is interim benefit delays. So when an individual files their I-485, they qualify for work and travel authorization, the C-9 EAD, the advanced parole, work travel authorization. USCIS calls these interim benefits. USCIS recognizes that green cards may take a while to process. And as we've seen recently, there's been retrogression. And so they created these interim benefits to give individuals quasi-green card benefits, visa-free travel with the advanced parole, work authorization, while the 485 is pending. Unfortunately, despite these documents taking very little time, I think 16 minutes for the I-131, USCIS is delaying these. And the good thing for the EAD is once you get it, the automatic extension of 180 days is there, but that's not there for the AP. And when you travel without advanced parole, there's a possibility of jeopardizing the 485 and getting the 485 abandoned. Now, that may or may not be true if you are on H or L status. You can travel on your H or L status and come back in. Would recommend talking to your attorney before doing that, making sure it's clean. You don't want to jeopardize your 485. But the advanced parole especially is extremely important, and people need to have that. Now, the good thing is USCIS is approving those for 5 years, but they're still delayed. We've been doing a number of these cases on individual bases. And when I say individual, I mean family units for these delays under the Administrative Procedure Act. These types of cases require us to look at the harm. What is USCIS's rule of reason, and are they following that? And truly, I don't think they are. When you look at interim benefits, the question really is a 485 pending? Why does that take 15, 16 months, like some of the service centers are doing for advanced parole? And so we've been doing these as individual cases, and the reason why, and I think a lot of attorneys out there, and I would agree, I think group cases are great. You can show a holistic problem. Obviously, individual cases reduce costs because you have more people. But one of the issues we saw with group cases in the H4 and H4 EAD context is the government kind of got tired of those cases and started filing motions to sever and transfer. Those are just procedural motions, basically, that would argue, Judge, these are all unique set of facts and they should all be separated out. And I don't think I agree with that argument, but the problem is that gets stuck in court fighting over a procedural matter rather than the substance of the motion or substance of the delay. And look, if the government wants to fight on the substance, fine, let's do it. Happy to fight on if they have a rule of reason and the reasonableness of the delay, but nobody wins when we're fighting on a procedural matter. So that's why we started doing these as individual cases, because I think it provides more of a benefit, right? If the government wants to fight on the merits, fine. Let's not fight procedure. So the interim benefits cases, are going pretty smooth. Always have the option of the government fighting it, whenever they decide they want to. But I think these are good cases. I think that there's very few arguments that they could make in the context of interim benefit delays when you look at how simple the decisions are for those. Kind of leaning off of the interim benefits, we've done a number of 485 adjustment of status delays. Now, the big thing here is not as many recently, especially with retrogression in the visa bulletin, which I'll talk about later. But when you are current and it's been pending for a long time, we have taken these 485 delay cases forward. And I think these are more technical than the interim benefit delays because there's a lot of unique law that goes around 485 delays. There's a lot of courts that think they can't get involved in 485s at all. And you look at the Patel case coming out of the Supreme Court a year or two back, and there's a lot of courts that think we can't touch it at all. Why? Well, 485 is discretionary under the Immigration and Nationality Act. The Attorney General, in their discretion, can allow a non-immigrant to adjust status. Now, the flip side of that is that in Administrative Procedure Act, you can sue on something that is a discrete agency action. Here we've got that. It's a form. It's a receipt notice, right? It's one document that the agency is required to take. And there's been some arguments from the government that says, look, because this is discretionary, we're not required to do an action, so we can delay this forever. The counter argument has been that USCIS created regulations that require a decision, and so they've made it required. So 485 delays are something that I think is worth fighting because you don't want to be subject to more retrogression. You want your green card as soon as possible, start getting that citizenship time. But there are things to consider. I think there's more routes the government could take in fighting 485 delays than some other benefits. But there's still good cases to look at on a case-by-case basis. You know, what's the harm you're facing? How long has your case been pending? Each of these cases is going to be unique. Another case that's kind of crept up is 221G or administrative processing. The consulates a lot of times will issue 221Gs or stick a case in administrative processing, and it gets stuck in a black hole. And what I mean by that is it could be 3 weeks, it could be 3 months, it could be a year, it could be any number of time that your DS-160, your visa stamp, is going to be adjudicated. And some of the 221Gs are asking for things that are unlawful. They're asking for end client letters, they're asking for vendor letters, and they're slowing down the process, asking for those for months at a time, even though courts have said they're irrelevant to the processing of a H-1B. Quite literally, the Department of State hasn't gotten the memo from judges that it's unlawful to ask on those. And the problem with these 221Gs and these advanced paroles is you have individuals that are stuck abroad, their business can't function, the employer wants them to hurry up and get back, and able to work. We've brought a few of these cases, and we've seen some motions to dismiss. I'll be frank. The government in DC filed a couple motions to dismiss on these cases where they're saying, Judge, 221G is a refusal, therefore consular non-reviewability applies. And that's a doctrine where courts can't review consular decisions. Now, there's a very good case out of DC recently where the judge said, no, like, you're not treating a 221G like a refusal. You're treating it almost like hey, we're not doing it for now. We just need some more stuff. And said, no, this isn't a refusal. This isn't consular non-reviewability. And so I think the avenue for these 221Gs and these admin processing cases is even better right now because of that case law. And that's one court in DC. That doesn't mean cases across the country are all going to come, courts across the country are going to all reach the same conclusion. Judges can reach different decisions until a court above them says differently. But right now, I still think those are good cases. We're seeing some good results on them. Like I said, we've seen some pushback from the government as well, but they're worth looking into. I've seen cases that are pending a year. I've seen cases that are pending 5-6 months, and it's just, there's no reason to let this sit in a black hole. It's kind of like FOIA, right? We've done Freedom of Information Act litigation because they don't get processed in time, and they should. The 221Gs at AP, are pretty good cases because of the way the government handles just sitting there and not adjudicating them at all. But they're going to be very technical. Again, there's a lot of avenues I think the government could try to argue, and they're going to be, again, case-by-case basis. So those are the cases we kind of have ongoing on a rolling basis. I've done others. We've done some delays on H4 still, unfortunately. Thankfully, that's getting a lot better, and we're not doing a lot on the H4 EADs. But there is still some of those issues out there for the initial more so than the extension. Also with my colleague from another firm, Brad Banis with Banis Law, he and I have been working on these retrogression hold cases where individuals retrogressed and then had their final action date current at one point, retrogressed. We believe that it's unlawful for USCIS and Department of State not to adjudicate those. We have a lot of those cases up on appeal right now, which is where we thought those were going to go eventually anyway. So hopefully we get some good decisions there soon. One of the cases we're looking at filing in the next couple of weeks is our Left Behind case. In September of 2022 and August of 2022, USCIS and Department of State worked to adjudicate a lot of employment-based green cards. And I commend them for doing so, but what they did in a lot of cases was adjudicate the primary, but not the derivative spouse or child. And this creates a divide where the primary is on a green card and the spouse and or child is still on a 485 pending, or they're on their non-immigrant visa, whatever it may be. And we're looking at filing a case here in the next week or so because the statute that deals with this says derivatives shall be entitled to the same classification in the same order of consideration. And USCIS is interpreting this differently, for sure. They have it on their website saying they're interpreting it differently, but we tend to think that entitled to the same status means they should have the same lawful permanent resident status, and it should be done at the same time. Otherwise, kind of like the 221G cases, it's an unlawful withholding. You're not, you're breaking the law to not give something. You're violating the law to not give a document that Congress has said they're entitled to. So I think we're going to see how that one goes. It should be an interesting case that we'll see how the government wants to handle that matter. I think when you look at the statute, you look at, when that statute was added in the 60s, it was all about family unification. I think it creates an interesting case. We also have a pending perm lawsuit, and unfortunately what we've run up to is a judge who hasn't really wanted to pick up the case, which is unfortunate. But hopefully we're looking at doing another one of those once that one kind of moves forward a little bit from the judge. We hired an expert. We know what the government tends to argue in delay cases, and so we hired a expert. Department of Labor has all the perm data up there for years. And when I say all the perm data, I mean it's literally the information on every box on the perm form comes in an Excel available online. And we took the expert and we said, take a look at this. What does first in, first out look like? Well, it's not there. They kind of handle cases at random. There's a wide standard deviation. And I wasn't a statistician for a reason. But I, talked with our statistician, and the case data is very wonky. We see, instances where two individuals file on a Monday, let's say, and there would be a wide spread between when individual A and individual B get adjudicated. And if they're doing things on a first in, first out basis, how is that the case? Not to mention the fact that when perm came about in 2004, the idea was this was going to be handled by computers, with programming for random audits as well as targeted audits for certain flags. Why these take a year for a computer to do is beyond me. I know the government's probably still working on the same technology as 2004, but it's certainly improved, and they should be getting better instead of worse. Funding's the same. Funding's better, actually, for Department of Labor, so they can't really look at that. But a lot of these cases, reach out, Stephen at rnlawgroup.com or info@rnlawgroup.com. Always happy to discuss your unique situation. And, these are just some of the cases we're doing right now. I think the most common anyway, the interim benefits cases, the 485 delays, the 221G administrative processing delays. We've done some denials on H-1Bs, cap H-1Bs that are getting denied. I think your best avenue is litigating rather than appealing, because the appeal entity really plays backstop to the adjudicator. They're going to look for ways to uphold the denial rather than really give you a fair fight. But litigating that case, a denial of any sort, but especially cap denials, cap H-1B denials, can lead to a judge making that decision. Now, whether USCIS acted arbitrarily and capriciously, or whether they followed the standards set forth in the regulations. And spoiler alert, they don't a lot of times follow the rules when they come up with these denials. So always happy to chat about denials and delays that you may have on any type of benefit. These are just some of the most common ones that we're doing right now. But again, feel free to reach out and happy to discuss. Hopefully not your denials, but I know unfortunately with USCIS, delays are just the name of the game. And hopefully we can come up with a solution. And maybe litigation isn't the best option. Maybe there is another way to go about it. But litigation can be helpful in many ways, and happy to discuss those options. Again, Stephen Brown with Reddy Neumann PC. Happy to discuss any litigation needs you might need on the immigration delays and denials. Thank you.